about the intersection of estate planning and marital planning. Hannah and I have met a few times over kind of in that context. And so I'm going to just introduce myself. So I'm founding and managing member of Vandenack Weaver here in Omaha, Nebraska. My practice is primarily tax. I do a lot of business succession planning, general tax planning, a fair amount of estate planning, and some asset protection. Do a fair amount of presenting. One of the things I like to talk about this topic is there's a lot of life events that will interfere with people's testamentary intents. I put a lot of energy into talking about how to protect what people want to have with their assets, and sometimes when getting married, there might be considerations for before, during, and after, and that's what Hannah and I are going to talk about. So speaking with me today is Hannah Summers. I'm going to let her highlight what she wants to talk about herself and introduce what she does.
Yeah, my name is Hannah Summers. I'm a divorce and family law attorney at Silvercheck Albers, and at our firm we focus on high conflict, complex identification and division of marital assets. And I'm happy to join Mary today. And I think that you will find that the intersection of what both of our practices focus on will create sort of an interesting point of view for your practices going forward, whether that's estate planning, family law, or both.
So there's a lot of things we won't cover, but we just want to point out some areas where I really am an advocate of collaboration among professionals. I think clients are best served if we do a little bit better job collaborating. I know some of us do a little of both. I pretty much focused on my end and have had the opportunity to collaborate with a lot of different ones. So we're going to just talk about some of the areas that they intersect. We aren't going to go into depth on the details of types of trust or all of the things. We're just mostly focusing on the intersection, but I think you can feel free to follow up with either of us on some of these things. And we're breaking our conversation today down into sort of the premarital planning type of discussion, and then things that you should think about during the marriage. And then if it does go down the path of divorce, then we'll talk about that type of issue. So the premarital planning is the premarital agreement, and Hannah's going to speak to just a little bit about the Nebraska statutes on what's permissible in the premarital planning, and without going into major details. Do you want to speak to that, Hannah?
So Nebraska has adopted the Uniform Premarital Agreement Act, and you can find that in the Nebraska Revised Statutes, Chapter 42, and then sections 1001 through 10011. I believe that's correct. I may be a couple off on those last numbers there. But the Uniform Premarital Agreement Act statutes allow for the rights and obligations of each party to identify property that either or both of them, whenever or wherever located, and how that will be divided in the event of death or divorce. And property means an interest, present or future, legal or equitable, vested or contingent in real or personal property, including income and earnings. And I think that last bit there, which is found in 421002, is somewhat of a focus in our conversation today.
And so the premarital agreement has a variety of purposes. So a lot of people think the purpose of a premarital agreement is, what happens upon divorce. You can really cover two different things: what happens upon death, what happens on divorce. Sometimes it's a second marriage. These days it's more common to see premarital agreements even in first marriages. But one of the things that you're doing in these agreements is to really focus on identifying each party's separate assets. So it's clear when you go into the marriage, these are the separate assets. And we'll talk a little bit more about the difference between separate and marital assets as we go. Then we define the income that will be considered marital income, which we're going to also talk about a little bit. If you have children from if one of the parties has children from a prior marriage, you want to preserve the rights to support those children, and maybe it's pets or something like that as well. And then it's to clarify the types of income and assets that will be considered. I think you're going to tell us a little bit about the Door case, Hannah.
So the Door case is a current case, and since it's pretty recent, I thought it was a good example to show what the court deals with on a daily basis in divorce if there's no premarital agreement. The Door case outlines some of the common messiness involved in assets that have been commingled and not kept separate during a marriage, and the impact of trying to have the judge decide those assets at trial if there's not good evidence showing who they belong to, how they've grown, and the impact of the Stevens case from back in 2017 is a big player in new case law that's emerging in the divorce arena in Nebraska. The
So let
Stevens
me
case,
ask you a question on that, Hannah, before we go to the Stevens case. So if you're just to tell me the key point of the Door case, so one of the things is some of our clients will have premarital agreements and some will not. So there's really two things that planners need to think about, right? Is if you're, like if I'm doing estate planning for a couple who's gotten married and they don't have a premarital, is the analysis that different from if they have a premarital agreement? I mean, I still have a starting point of separate assets and marital assets, right?
so the big picture in Nebraska is that we're courts of equity, and that means that property can be allocated between the parties in the event of divorce, either 1/3, 2/3, 50-50, or anywhere in between. And if you have a premarital agreement, then you are able to identify, classify, value, and decide how you want that property to be allocated in the event of divorce. Whereas if you don't have a premarital agreement, then the court is in charge of identifying, valuing, and dividing the net marital estate. And so in
Still
Door,
have, even when you've identified in a premarital agreement separate property, and we're going to talk about this a little as we go, the separate property can still be murkied up by what the parties do during the marriage if they don't maintain those separate assets, right?
correct, especially if the premarital agreement is not precisely clear on either proceeds of separate property or income from separate property. If the premarital agreement does not specifically set off those items that may be related to separate property, you're still going to get into a messy situation.
So as we are planning in the premarital context, there's basically two things. What is the separate asset? And we want to identify very clearly what those separate assets are in the premarital agreement. But the other issue is income. And what I've seen in some premarital agreements is there's not enough consideration given to this, but there's passive income and active income. And we'll jump to the Stevens case in a minute, but let's stay really conceptual for just a minute in discussing what should be addressed in the premarital agreement. So the passive income on a marital asset, that's usually a marital asset, correct?
So
they have an asset they acquired after marriage with marital income, marital asset. If it's, a stock account they hold in joint tenancy and they both contributed to it from marital income, the interest and dividend income on that is typically marital, right?
Correct, yeah.
But if it's a separate asset, so if I have an asset that's a separate asset and I'm earning interest and dividends on that, the asset remains separate as long as I haven't commingled it. The income from that's a separate asset and should generally be mine. Now I could take that income, use it within the marriage and kind of convert it into marital asset, which we'll talk about again later. But essentially my income, which is really two pieces, there's interest in terms of income and dividends, that type of passive income, and then there's gain. So is there a distinction in Nebraska between those two things on a separate asset?
So from the Stevens case, the court identifies active appreciation as growth that...
Well, active, so I'm still talking about passive though.
Okay.
So if it's so if I have a separate asset and my income's passive, that's mine, right? And that's whether is my interest and dividend considered passive?
So yeah, if you have a gift or inherited funds that are in an account and they grow without your active contribution or active direction, then that's passive income that should be set off as a separate asset.
And so then, and the question becomes of the Stevens case, that's a really interesting case in Nebraska and does vary a little bit from a lot of states. comes with the family business. So historically, you would have looked at if I owned a family business, whether I owned it because I started it or whether I received it by gift or inheritance, that stock in my family business should have been a separate asset and I own the stock, okay? And there's been a variety of cases over the years that say, well, if you didn't take adequate income out, that maybe should be considered. But the Stevens case, which I'll let speak to, is kind of turned that all upside down, and you have to be really careful in addressing this in the premarital planning. But why don't you just give us a rundown on the Stevens case, and then we can talk a little bit more about that.
So the Stevens case really addresses whether when active appreciation becomes an asset that's divisible in divorce, and active appreciation would be growth on an asset that was attributed to marital contributions, whether that's somebody's employment where they're also earning income, but if it's stock in a company and that person is directly related to the success of the company, so top tier management, if their stock appreciated during the marriage significantly or not, and that stock appreciation was due to that person's management of the company, income aside, then that's active appreciation, which the growth related to that active appreciation, even if you set off the value of the premarital stock, that growth is still divisible in divorce. And that becomes a marital asset, just like real estate or vehicles that can be stuck on that balance sheet and added into the net marital estate for division.
And that's even if they are actually taking out a fair and reasonable salary, right? Which is where I actually take issue with the case, because let's say, and I actually have a client in this situation right now who owns a family business, and a good chunk of it was received by him by gift from his dad, and so it was worth, not a lot at the time of the gifts were made. It's worth a fair amount of money today, and so the worry is he's actually taken out a reasonable salary over these years, and if you compare the salary, which is an argument I'm trying to make on his behalf, I'm supporting the family law attorney not doing family law. I leave that to those of you who actually don't mind going to court, which is not my deal. But we're trying to take the position saying, well, look, at the end of the day, if you look at the average salary paid to a guy in this position in a publicly traded company, he's getting paid just as much. So that income, to the extent that's going in the marital, should really kind of undermine this case. But that's not the state of the law, at least in Nebraska right now. So in the premarital planning, you've really got to deal with that growth. So once upon a time, I would exclude, the income from any separate assets, and I might have thought that was broad enough. What I've gone to in my premarital agreements now is specifically excluding having them agree identifying the family-owned business. That doesn't help if they started after marriage or receive gifts after marriage. Well, it might. But that's what I'm doing, is specifically identifying, is there anything different that you think we should be saying in premarital agreements to cover the Stevens situation?
I think the main point in Stevens is the differentiation between active or passive appreciation on a premarital asset. And I think you have to identify not only if you want to set off the closely held business that was owned prior to marriage or gifted to the party during the marriage, but you also have to set off the income arising out of that, proceeds from any sale that may be related to that business. But that's only if you're doing a premarital agreement where you're trying to set that asset off entirely, and notwithstanding any provisions that may still allow for somebody to receive certain sums of money, alimony or otherwise, depending on the length of marriage, or other stipulations that you may include in the remaining body of the premarital agreement. But for purposes of keeping entirely separate property, you want to identify and specify that not just the asset, the business itself, but also income that person may receive from that business, stock, otherwise.
But it does change the way you need to draft and think about the language in your premarital agreement. So most people have some kind of standard language, which I never really consider that a template. I think you have to look at the newest cases every time you write one and consider that. But I have to tell you, just since that case came out, I've really grieved over what my agreement should say. But let's talk a little bit about then. So what's really important is to help clients, and whether or not they did a premarital. So just often that they don't, they come into your office. But to the extent they own something before marriage or inherited something, that's technically still a separate asset. And people think, well, because they didn't have a premarital, it's all marital. That's not necessarily the case. But let's talk about, to the extent you have separate property, how do you help keep that property separate?
So basic tips would be to maintain separate accounts that are titled explicitly, this is my separate inheritance or wife's separate inheritance, and then you don't actively invest, you don't, and whether that's, you know, with stock or changing the nature of the investment, whether that's if you purchase real estate or whatnot, if you start changing the character of the separate property, you get into a big mess with trying to figure out, is that original separate property traceable and identifiable onto itself? And if it's not, then what has caused it to change? And if that change has led to appreciation in that separate property, is that due to active efforts or passive efforts? And if they're passive efforts, then it should be set off. But if they're active efforts, that's where Stevens has really changed the game with identification, valuation, and division of marital estates and divorce.
And you introduced me to the Schnackle case here in Nebraska. And I think that we just throw it on here without a whole lot of details, but it gives a good good explanation of separate assets and how things kind of flow in that. Do you want to just, I thought the facts of that, Hannah, I really liked that from hearing about those facts from a planning perspective and talking to clients about it. So you just want to share like a brief overview of that.
So the most relevant portion of Schnackle for purposes of this presentation, the fact pattern is that the wife received an inheritance, and then she put that inheritance into an investment account. Then she moved that money from the investment account into a mutual fund. But the court decided that since she only transferred that money that was originally inherited 2 times during a period of 6 years, that the court still decided to set that inheritance off as separate property and did not include the appreciation on that asset in the marital estate, which is where Stevens sneaks in there. Because if the court would have viewed the transfer of the funds, the investment of the funds, or the changing of where the funds were invested as active, then any growth on that inheritance would have been included in the marital estate. So in the Schnackle case, the court, was pretty adamant about drawing some sort of line there to say that these 2 transfers of these inherited funds did not qualify as active appreciation to make that appreciation a marital asset that's divisible in divorce.
And so one of the things, like I actually have a client who, for a variety of reasons, what he does is they have a variety of family assets, and he manages the family assets. So in that case, if there were a divorce, the spouse would have an argument that any of that growth, right, in assets is actually from his active services and subject to being a marital asset, correct?
That sounds pretty active to me, yes.
Yeah, well, I'm pretty sure he doesn't think that. So I have to talk, we're going to have a conversation about that after we have collaborated on this. And one of the other things in the estate planning area is that I always talk to estate planners about, okay, and so I didn't quite mean to flip away from that yet, but is avoiding just this estate planning assumption, historically, and, even when I first started it, because of the way the estate tax was structured, you'd kind of split up the assets 50-50, which there's a lot of ways not to need to do that. There's still some reasons. But what would happen is sometimes attorneys will just split the assets half and half. We want half over here and we want half over here because that will work, and might not consider the fact that those assets were separate assets. So they take an asset that was separate and they give all or part of it and trying to balance out the assets to the other spouse. And in doing that, they may have just commingled that asset or made it a gift or whatever the case might be to the spouse. So you really have to think about, and one of the questions I ask clients in the estate planning process is the source of the asset. Were any of these assets gifted, inherited, or the proceeds of a gifted or inherited asset? And let's have a conversation about what that looks like. Any other just quick thoughts on what people might want to think about keeping assets separate?
So there's another quick case that I'll mention here. It's Sellers v. Sellers from 2016, where the Nebraska Supreme Court concluded that a transfer of an LLC from husband to wife was a gift, despite the husband contending that that transfer was only for estate planning purposes. And so what may have been a separate LLC to husband in that case was then a gift to the wife and entered into the marital estate.
So be careful about making estate planning transfers, because there's still a chance of divorce and a variety of other issues. So it's keep that separate assets separate, titled separately, and avoid what you do be careful with what you do in terms of gifting. And again, there are a lot of estate planning strategies today that can avoid those needs to transfer. And avoid the commingling. That's the other big one, right? So
that one's huge.
And I've seen that in, and it was once upon a time when I used to get involved in doing some of the tracing. It was just a real estate guy, and his spouse had to sign off on all of his transfers, even though everything was in his name, and got credit for that being consideration. The other thing is sometimes you have, like I have a client who has a business owner, and we talked about the bank wanted spouse to sign off as personal guarantor. We argued with the bank, blue in the face, he's not involved in the business, blah, blah, blah. Ultimately, to get the business going, she had to have the spouse personally guarantee. When you start having personal guarantees, there's some at least claim to contribution, if not a commingling. The other common one I see is somebody gets an inheritance and dumps it into a joint account. And those are the things you just really want to spend time talking to clients about. And I do that in the estate planning context. Let's just talk about what you want to do. So other concerns about estate planning. So sometimes a client will have estate planning documents. This is most commonly an issue in a second or later marriage. They might have kids by a prior marriage, but they have documents, maybe an irrevocable trust. An irrevocable trust is technically outside their estate, but I still cover them. And that's a conversation you and I had in preparing for that, is we prefer to say things covered rather than rely on things. It's pretty standard in a premarital agreement that both parties are going to waive their rights to elective shares in the premarital agreement. One of the things I cover in the premarital is, okay, you're going to waive, elective share rights, but are you going to agree to actually give something? And that's always a conversation that I have with clients in terms of that premarital planning. There are some trends. One of the things that I've gone to doing that I didn't, and once upon a time I would tell clients that if they were the beneficiary of a third-party trust, which would be a trust created by somebody else for the benefit of the beneficiary, that would be it's an inherited asset, separate property. We've seen a trend, most egregiously in Massachusetts. Seen a couple cases in California. Hannah assures me it hasn't happened in Nebraska. But one of my points is you have to remember that the person you're working with sometimes moves to a different state. And so when you're drafting premarital or estate planning documents, I always suggest considering the trends in other states, so that if it's your client that happens to be the one who moves to Massachusetts, where there's been a recent trend to include third-party trust as a marital asset, that you're aware of that trend and give some thought to what you're doing in the premarital agreement. what I do, and not all parents want to disclose to their kids who are getting married exactly what they have in place. And so you don't always have the specific names of the trust, but if you can and the client can get them, personally, I go ahead and identify any trust that's in place or even expected inheritance, which I didn't used to do. Once upon a time, I just said, as long as it's inherited, it's going to be a separate asset, no problem, don't worry about it. So ERISA, so this is one of the challenges. What happens with the ERISA benefits in the premarital agreement, Hannah?
Well, and I'll just back up to that last slide. I would double down on the last point you made there, Mary, because I think Stevens comes into play with anticipated inheritances that are received after a premarital agreement is signed during the marriage. And if that includes a business where the person has an active role, then you fall right back into what is growth that is marital, or has that been set off in the premarital agreement. So.
And so ERISA is another fun area. So in the premarital agreement, so typically a spouse has rights under ERISA in the spouse's any qualified retirement plans. And they can waive that, and what we talked about is in their premarital, but I liked your approach to after marriage. But you want to speak to what you like to have clients do in that context?
Sure. So if parties are not taking an interest in the other soon-to-be spouse's retirement accounts, then we always have them sign a reaffirmation to waive their interest in the other party's retirement benefits after they've been married. So they execute the premarital agreement prior to marriage within, sufficient time according to the statutes, and then after they're married, they reaffirm that waiver.
And so how do you make sure that happens? I actually try and get them, find out what the wedding date is and get them to schedule a meeting.
That week, yeah.
And at least because if you just send it out to them, sometimes it gets lost. And I had a case where we used to routinely just send them out. And then, there was one case where we didn't follow up and it didn't get signed. And so now we actually try and we have them schedule a meeting. And if they follow up and send us the signed documents before then, we don't need the meeting, but we try and get that in the calendar. Do you have any other strategies you use?
I just do it as soon as they're back from the wedding. And it's a good point to reiterate that those aren't filed anywhere. And so if you don't stay on top of your files and calendar it for yourself, then that can certainly get lost and be the case.
So an asset I like to talk to you from a premarital planning perspective is the current amount that you can transfer estate tax free. So it's our estate tax exemption amount in terms of how much you can pass to beneficiaries. So for the most part, everybody assumes that the moneyed spouse has all the leverage in negotiating a premarital agreement. So I just like to point this out for the non-moneyed spouse. They do have some potential value to the moneyed spouse in that they have currently, after we've dumped trillions into the economy related to COVID, I'm not sure that this won't sunset in a couple years, but you have an 11.4 exemption. So if you have a spouse who doesn't have money, this exemption is actually portable from one spouse to the other, and or it can be used during life. So we had for the joke among estate planners when this portability came out that it's, that you marry, gift, and then kill. And that's kind of the way this is structured. And then you marry, and then you can get a whole lot of exemptions through this portable spouse. But a spouse could agree to provide the benefit of her exemption. There's a variety of strategies that I won't go into detail, but it's at least something to think about in negotiating a premarital if you're negotiating for the less moneyed spouse. And another alternative to the premarital agreement is the asset protection trust. So technically, and there's several states that allow for what's basically a self-settled trust. So I create a trust on my own behalf. And you could go to one of those states, create a trust, transfer assets. There's a lot of commentators that will tell you if you use this approach, you create separate assets. That, I think Hannah and I agree that you do. There's some commentators that will say, oh, if you do this, you don't even have to disclose the assets in the premarital agreement. I think that both Hannah and I are like, well, okay, it's probably not you don't probably have to disclose disclose it as part of your balance sheet, but we think to avoid the argument later that you would at least include as a footnote to the financials that that asset protection trust exists and what it exists of. Any other thoughts on that, Hannah?
I would agree. I think better safe than sorry, and more specific in the identification of the assets when you're signing the premarital agreement is always the safest route to go from the divorce lawyer's perspective.
And so the general thing about asset protection trust to know is that, and you have to look at each state that has these trust laws, which change almost annually in each of the states. So whenever I'm working in asset protection areas, I have to revisit what the current state of the law is with respect to asset protection trust, or even, sometimes it's not always about an asset protection trust, but just Sidus. But the thing is that spouses before marriage, so it'd actually be the fiance or whatever, is typically not an exception creditor with respect to an asset protection trust, as long as the trust was created by marriage. This strategy does not work once the marriage has taken place. So we talked a little bit about the portability. So marital trust planning, this is one of the strategies to use part of the exemption for the less moneyed spouse. So it's a Q-tip trust that is created for the spouse using the exemption, ultimately gets to the beneficiaries, maybe go back to the spouse's preferred beneficiaries, however that's structured. There's a whole bunch of ways to structure that. Lately, there's been a lot of formula planning of different types in the estate planning context. Well, typically the formula planning, so you might say, well, I'm going to rely on the estate tax exemption amount in terms of a formula. Well, if the estate tax exemption jumps around the way it has, so back in 2012, we all thought it was going to drop back to $1 million, and instead it went to $5 million, and then it went to $11.4 million, and now it might go back to $5 million. So using a formula based on the estate tax exemption can really create some havoc, and I typically don't use that if there's a premarital agreement in place and we're doing some of these structures. So I avoid that. If there's no premarital agreement, just maintain separate property. We've really already kind of covered that. The other trend to be aware of, I mentioned the Leviton v. Rosen in Massachusetts, but there's a variety of states that have found ways to treat third-party trusts. So again, I used to tell mom and dad if they were drafting a trust for their children, whether those kids are 50 or 30 or I don't care, but that this is a third-party trust, it's going to be protected property. There's been a trend in several states where they will look at the terms of the trust that's drafted for the beneficiary and will say, well, actually the beneficiary has a property interest in this trust. And that property interest is, so big surprise to mom and dad who thought they were helping their child keep their assets separate in the event of divorce. And the other thing is that sometimes, even if it's not determined to be a property interest, they might look at an income interest in terms of saying, well, you've been taking out distributions of $5,000 a month from this trust during your life. And Hannah, that might be looked at in terms of a variety of things in the divorce process, correct?
That's correct, Mary. Yeah, income from all sources can be used when the court is considering child support, alimony, overall division of the marital estate. So if someone is receiving current and consistent income, the court, as a court of equity, can factor that into the overall outcome of the divorce, even though it's not necessarily a marital asset that's going to end up on a balance sheet or anything like that. But at the end of the day, if the court was going to order alimony and then somebody is receiving significant trust income, the court may not need to order alimony after running through the factor list in the statutes.
And so some of the things I suggest to planners to look at in doing when they're drafting trust for, there's two contexts, both the couple that got married, what you're drafting for them and talking about that. But a lot of times I'm thinking about the parents who are trying to keep and protect, would they create a third-party trust thinking they're protecting it? A lot of us will have spendthrift clauses that are just kind of in our form. And I really encourage drafters of trust not to just use a form spendthrift clause, but actually have a conversation about it and make that unique to the specific situation. Be careful if you name the person who goes through divorce as the trustee, that's going to lend itself towards it being a property interest. I like to use the trust protector. We have a directed trust statute in Nebraska now. The concept of trust protectors gotten pretty well recognized nationally, who can terminate interest and things like that in the event of a divorce. The distribution language should like literally avoid saying, well, you're going to distribute to my child that $5,000 per month every month, because that's more likely to be looked at as an interest that's going to be considered in the divorce. If you have a trust for just one person, that's the same thing. They're more likely to be considered. So let's say you create a share for somebody, you name them as trustee, and you say you're going to distribute at least, well, that's probably going to lend itself towards an asset that will be considered in the divorce. So those are some of the things to avoid. And one of the things to discuss, and it's always difficult, but I always couch the conversation by, well, you know, people say, well, I want to give everything to my spouse. And I just say, okay, now, is it okay after if you die and then this all goes to her new spouse? And that always changes the conversation. But one of the things to consider, and it should be a conscious decision, whether the rights of the spouse should be terminated in the event of divorce or separation. And I actually, my documents currently say, you know, upon a filing, the rights are, and not the rights, because you have to look at two different things, but we terminate them as a trustee and all of the capacities that we can. As far as what interest you can terminate in terms of property interest, some of that was going to depend on the type of trust and, you know, any premarital agreement, whether there is one. So trust situs matters. Oh, in the event of the divorce, let's talk about that. What can somebody do? So divorce file happens, Hannah. They should review their wills and trusts. What can they do? We talked a little bit about that.
I would highly suggest that any client who is finishing up their divorce redo their will, their estate plan, to make sure that they aren't giving certain assets or transferring anything to their ex-spouse if that is not what is intended. And I know that in some trusts, if the language is not specific, if it's naming a spouse or if it just says spouse, I think those are some things to look out for when discussing who is eligible to receive interest, whether that's pursuant to a trust or not. I think this specificity in language, when you're talking about my spouse and then you say that person's name in the body of the document, that is more clear that you're indicating that you're transferring something specifically to that person. But if you don't say my spouse and then their name, you just leave it at my spouse, if you're remarried or once, twice, three times, that could have a different meaning than what was originally intended if you leave an estate plan alone for too long. For purposes of changing beneficiaries on life insurance policies, you want to make sure that you do that as soon as possible after the divorce if the intent is to not have the assets go to your ex-spouse. You can leave that person named as a beneficiary and it won't be automatically revoked, but most people don't intend to deliver assets or transfer assets to their ex-spouse via life insurance policy or account where they're listed as a beneficiary after divorce.
So the Nebraska has a revocation on divorce statute. Exactly how does that work in Nebraska? What gets revoked? So life insurance beneficiary, does that change or not?
No, so people actually have to change their life insurance beneficiaries.
Retirement account, they still have to change, correct?
Correct.
So you just can't overlook. And the other distinction I want to make as we're talking about this is that there's during the pendency of the divorce, and then there's after the divorce. So like the revocation on divorce statute doesn't do anything during the pendency. And so
Correct.
they actually waived their elective share rights. You could make a change to your trust if you have a premarital that waives the elective share, correct? And you can remove the spouse's trustee. You can remove them in any capacities that they're serving under the trust. You sort of have to be open and above board of that, I think, as long as you're in the divorce process. Would that
And I
be?
think premarital agreement is definitely key there. If there's no premarital agreement that states that there's no interest there, then I think you have to be careful.
Okay, and then I like to, again, talk about the trust Sidus matter. So it's sort of like, okay, what can you do? And this is just keeping in mind that your client sometimes moves out of state. And this In re Cameron gift trust was not, so South Dakota, our neighbor up north, is known to be a pretty solid asset protection state. And it's one of those states that when I'm doing asset protection that we use it fairly consistently. This case, in Ray Cameron case, wasn't actually an asset protection trust, but it was kind of a victory for asset protection and for Sidus changes. So a gal lived in California. She got divorced out in California, had children out in California. A trust had been created for her by her parent. She moved to South Dakota after the divorce was final, and changed the Sidus of the trust to South Dakota. Ultimately, a California court said, hey, this trust, they ordered the trustee of the trust to make payments of child support, attorney's fees. In California, this case would probably have enforced that, but the South Dakota court said, hey, you moved to South Dakota, you changed the Sidus of this trust, and the spendthrift provisions and the way those apply here are not, your California spendthrift provisions are not going to get full faith and credit, so this isn't enforceable here. So it's one of the things to look at in the planning, both premarital, during the marriage, or even after, if things go south and you're in the divorce process, is can you make a change to a trust Sidus? So we used to draft trust kind of contemplating it's going to be a Nebraska trust. And I don't do that anymore. I always draft the trust with and put provisions in there that allow for the change of Sidus and put some provisions in there about how that can happen. So we did talk a little bit already about the revocation of divorce. It doesn't apply to everything. Another thing that the revocation of divorce statutes do not apply to are irrevocable trusts. So if an irrevocable trust was created during marriage and the spouse is a beneficiary, that revocation on divorce does not apply to it. And again, the reminder that during the pendency of the divorce, that doesn't do any good. I think Hannah and I are both advocates of you shouldn't really rely on the revocation on divorce statutes anyway. It's be diligent about coordinating and cleaning up, and that's where we think there's a lot of collaboration opportunity. Change what you can. The other one that we talked about was the power of attorney for health care. So there's some states, and New Jersey is one of them, that says, okay, you named your spouse as the power of attorney, and she filed for divorce, and now you've got COVID-19, and you're about to be put on a ventilator, and she shows up as your power of attorney and says no. So this is something you can change in Nebraska. We don't have this statute, right, Hannah?
Correct, yeah, and everyone should make sure that those are up to date to prevent situations like that from happening.
And retirement accounts, we beat that a little bit up in terms of ERISA applies, and there's different rules under ERISA that apply to qualified retirement accounts that should be considered in that premarital planning, during marriage, and in the event of a divorce. And so those assets can get split. And do you want to just talk briefly about the QDRO?
So when retirement accounts are divided pursuant to divorce, they require a separate court order called a qualified domestic relations order if it's a qualified account, to avoid tax consequences, penalties of moving that money from one spouse to the other. That's basically all a quadro is for the purpose of divorce. There isn't much to say about a quadro for purposes of premarital planning. It's just how to transfer money from a retirement account divorce process.
So life insurance, again, it matters where you live. So in one of these cases, the life insurance proceeds, so the Sween case, did not go to the ex-spouse, even though she was beneficiary on the beneficiary form after the divorce and at the time of death. Well, in the Blaylock case, completely, another result was there was the revocation upon divorce statute applied. So this is a couple that got divorced. They got back together, but they hadn't gotten married, even though they were planning on getting remarried. And he dies. She does not get to collect the life insurance proceeds because the revocation upon divorce kicked into play. So that's, again, where Hen and I are both advocates of saying, really follow up on the planning and coordinate all of the pieces and kind of go down the checklist and think through all the assets, which brings us to other assets to consider. I haven't seen this. Hannah can speak to whether she's seen it in the divorce context, but I like to tell the story of a case in regard to Apple Photos, which was a significant case, and it was a death case. But so the husband died, spouse was surviving. She just tried to get the family pictures from Apple, and they wouldn't let her have it. It took kind of a big court case and a lot of gyrations to ultimately get access. So this is just another thing, estate planning, divorce, talk to clients about how that happens. If one has the account, and this I'll just throw at Hannah kind of off the cuff, if one of them has the Apple account in his name, what happens on divorce when she wants half the family pictures?
Well, then it's probably contractually it's probably a contractual agreement, whether that's in the decree or property settlement agreement, that is ordering the party with the pictures to share those. But I would just add, upon divorce, we always encourage clients to make sure that the ex-spouse or soon-to-be ex-spouse doesn't have their passwords to their email accounts, their PIN numbers to their bank accounts, or any shared accounts like that.
And we recently had somebody who went into the spouse's app, which I didn't know you could do this, and basically change names in the app with respect to the car. It was a car. It was a nice car that the couple owned, and she was the one who had the app and the vehicle, and the guy went in and actually changed a bunch of information on the app and made a claim, well, I own this. So that's, keep those passwords and things separate to the extent of that. So other assets, the trust assets, and we've actually kind of talked about this a little bit in terms of the trust drafting, but just knowing that they do. And I think, did you want to speak to any more on the child support guidelines and the income interest in trust? I think that's hugely important to understand, even if it's not a property interest, that income interest gets considered.
So if you're calculating child support, then the court can consider income from all sources. So if somebody is receiving reliable distributions on a monthly or annual basis, and those are foreseeably going to continue, albeit child support is modifiable upon meeting certain changes and circumstances that would impact the outcome or the obligation. But the court can consider income from a trust as income to be used for calculation of child support.
And this, we see a fairly significant trend of that across the country. It's one of the consistent things. If there's regular routine distributions being made to a single beneficiary of a share, right? That's the most common. But even in other cases, so if it's, that can't be, you've got to look at when you're drafting the trust, if you want to avoid that, is more than one beneficiary, don't have a set distribution amount, and this is a basic asset protection law with respect to creditors too, is a lot of people want to say, hey, my spouse can take out, or my beneficiary can take 5% a year. And if it's 5% per year, then typically that's going to be subject to creditors, whether it's divorce or other creditors. So you just want to be a little bit careful about the way you structure those income interests. And then trust created by parties to the marriage. So this is a consideration during the marriage. So this Loomis case out of Wisconsin wife transferred a life insurance to an irrevocable trust. And it was an interesting rule that was said, hey, this is an irrevocable trust. That means it's outside of their estate, and that asset was not considered an asset subject to division at all because neither the husband or wife. So this trust was created for other beneficiaries. And so it's one of the things to think about during planning if you want to make sure there's a really common estate planning consideration. I had a couple in recently, and there's kids from 3 different relationships. How do you plan for that, and how do you keep those trusts from being subject to, a divorce proceeding if that happens? And that's one of the ways that you can do that. Another case said, hey, Cupert, so Qualified Personal Residence Trust, had a resident transferred to it, and despite the fact that that trust was irrevocable, that got held to be a marital asset. Trust decanting, we didn't get that passed here in Nebraska yet. I think a lot of us thought it was going to go through, but that's a technique that you can essentially have a trust, set up another trust, and transfer the assets of that trust. There's a whole bunch of rules that are well beyond the scope of today's presentation in that. But in a case, again, out of Massachusetts, which is really interesting, Massachusetts is generally very favorable towards the divorcing spouse. But in this case, it's decanted. The trust assets were moved outside the reach of the divorcing spouse, and the court held in favor of that. So did you have any thoughts on those comments at all before I jump to our genetic material conversation?
Jump on ahead.
All right. So we were talking about this, and neither of us has seen a lot of this in the marital context, but it's just at least interesting for discussion to ask clients questions. Like, on an unrelated topic, I do a lot of gun trusts, and the first time I got asked to do one, I hadn't really made it a routine question for clients. Well, we're here in Nebraska, so now I always ask that question, and it's not untypical for a client to own hundreds of guns. I'm like, oh, glad I asked. And let's talk about how that should be part of your estate plan. Well, it's becoming more common for people to store genetic material. I had a story, and it was actually a friend of mine whose daughter got cancer, and so they harvested and saved her eggs. So if she dies, and then whose kids are those from an estate purpose, and how does that work? But in the divorce context, is like who gets what if there's been any harvesting and things like that. Is there any thoughts that you want to add on that, Hannah? I know there's not a lot of case laws.
From my limited experience, it has been looking back to if any contracts were signed with the storage facility, what those contracts say in the event that either party wants to no longer have that stored genetic material. But in the cases I've handled, both parties have agreed with what to do. So we haven't had to address that in court, or I haven't personally.
But we'll look forward to when we see you doing that and hearing about that case in a follow-up webinar. So when the divorce is final, and we've kind of beat that one up, we both feel strongly about following up with the update. So whatever you did during the pendency of a divorce, and make sure you go through every single asset, retitled, beneficiary designations. There's some changes, and I was asking Hannah what she's seeing here. So you have this change to the deductibility of alimony payments. And we're coming close to the end of our time, so we might just want to touch briefly on this. But there is at least a New York case where an award was reduced by the tax benefit for payments made before the law change. And I asked Hannah, like, well, what are you seeing in terms of negotiating this based on that change?
And most negotiated property settlement agreements, divorce decrees, or those that are tried to the court consider the non-deductibility of alimony to the payor. And so most alimony awards since 12/31/2018 have decreased from prior awards that may have taken into consideration the benefit of the payor to be able to deduct that alimony on their tax return.
And so just some tax issues, because those are my favorite. The transfers pursuant to a divorce do not result in recognition of income. There's some ins and outs on that. I do tell clients that if they're going through a divorce, they should have a conversation about, you know, if you don't want one spouse to get all the low basis assets and another spouse to get all the high basis assets. There's a huge difference in tax consequences in that. There was this repeal of Section 682, which, given that we're sort of at the end of our time, I'm not going to go into any details on, but generally a grantor trust, you might create a trust that provides an income to the spouse, but the grantor's taxed on that income. So this new repeal of Section 682 has created the situation where you can have a divorced spouse get the income and the other spouse is paying the tax on it. So that really does need to be negotiated if that arises in a divorce context. And we're waiting on some regs from the IRS, which got lost in the COVID nightmare. We really thank you for participating today. Hannah and I's information is on here. I'm always happy to take questions from anybody based on this, or just hear feedback or what you've run into so that I can improve presentations in the future. So thanks for listening. Hannah, thanks for doing this with me today.
Thank you, Mary.
Have a great day.